I get this question asked all the time. Say, for example, you get a divorce, you're paying child support, and then you remarry someone else. Will that new spouse's income come into play to your child support for the prior case? And the answer is if you have a new spouse, that person's income does not come into play. The court will only look at your income and your income only. Now, if your new spouse is giving you a weekly allowance, then that's a little different. Another issue that comes up a lot is retroactive child support. Say, for example, you have a child, 2 years go by, and your spouse files for child support. During that 2-year period, were you paying child support or not? The court can look back at least 2 years and say, well, if you weren't paying child support for those 2 years for your child, then we're going to retroactively apply the child support guidelines in order that you pay child support for those past 2 years where you failed to pay. If you're required to pay retroactive child support, typically you're not going to pay a lump sum. What the court usually does is they take your child support obligation. Say, for example, you're going to pay $500 a month towards your child support. Then they'll tack on an additional 20% of that child support amount as in for what they call arrearages. So total per month you would be paying $600 until that retroactive child support is gone. Another common question that I get all the time is, can we garnish my ex-spouse's wages? The answer to that is always yes. The statute states that if one party asks for garnishment, then the court shall garnish it, so that your employer is going to pay the child support directly to your ex and you have no say in it whatsoever.